So yes, in the last class, we were discussing about Gustav Radbruch's take on relation between law and morality. So his earlier idea prior to the war had been more in line with what legal positivists like H.L. Hart, believes. Okay, it's essentially that the crux of the idea is that um, law can be unjust. Okay, uh, and whether it will be valid or not will depend on the discretion of judges. Okay, the judges can, it will be up to the officials whether they think it is problematic or not. Okay, if they think it is problematic, they will say that it's not valid. Okay, so it leaves it up to the judges or officials to decide on it. So we discussed about this quotation that I'm referring to again: the legal certainty that positive law affords may justify even the validity of unjust or inexpedient laws, but argued that the demand of legal certainty has no absolute precedence over the demands of justice and expedience. Okay, so if conflicts arise between these, these qualities, in such case, how do we decide? Okay, that will essentially be based on your own individual conscience. So it will be up to the conscience of the judge. Okay, so yeah, judges will decide in individual cases. So it's going to be judges conscience which will direct them to enforce an unjust law as against a person who disobeys it because of their own conscience. Okay, so it leaves it up to the judges to decide on that. Okay, now we have seen in our previous discussion that's exactly the defense those officials came up with, who said that, well, we were merely following the law, we were merely following the orders. Okay, so that's essentially what the problem is. And then you have this entire holocaust in this atrocious event. Okay, now that brings about change in the perception of our philosopher. Okay, so yes, now essentially the idea that he holds is that well, I'll share a link with you guys on this. Okay, a Wikipedia link. You guys can refer to this. Just a second. I'll put it in the chat box. You can click on it. Okay, he comes up with a new formula, a new doctrine. Okay, and it says that we call it the Radbruch formula. Okay, it says is a theory of law which was first formulated in 1946. Okay. Okay, whatever it is, according to the theory, a judge, okay, we are referring to the officials now, okay, not individuals. Okay, according to the theory, a judge who encounters a conflict between a statute and what he perceives as just has to decide against applying the statute. Okay, if and only if the legal concept behind the statute in question seems either unbearably unjust, okay, unjust, or in deliberate disregard for human equality before law. So this is, if this is the situation, and then judge's question of subjective morality will not be relevant. Okay, judges have to come to the conclusion that this is an unjust law and we will not enforce it. Okay, this is the new position that he comes to. Okay, so we see that Radbruch argued that post-war German courts, okay, were right to convict the informers, okay, in disregard of Nazi law. So he's talking about it in a certain context. Okay, also known as what do you call it? The Grudge informers case. Okay, so here's what the Grudge informers case is. Okay, there are many. Okay, among others, one came to prominence because there was an entire debate between Hart and Radbruch, and then Hart and Fuller debate. Okay, so what had happened in this situation was that. Let me first introduce you to what Grudge informers case generally has been. Okay, so in Nazi Germany, it was made criminal, okay, under a Nazi statute. Okay. Sorry, what is it? Grudge informer case? What do you mean by that? Anyway, so what used to be, there was a rule, okay, a Nazi law that said that, okay, no one would be critical of the Führer, okay, or for that matter, the regime that they had, okay. You cannot have any different views, okay. You cannot be critical of Hitler, Führer, okay. And if you did, then there will be certain consequences. You could be executed as well, okay. So there were laws, okay, during the Nazi regime that made it criminal for you to be critical, okay. So there were cases of people, okay, who would come to know of someone they know, okay, who held such views, okay, such critical views of the Nazi regime, Hitler in particular, and they will then go and inform the officials, okay, about the same, okay. So when they inform the officials about the same, the matter is brought before the courts, and the courts have to decide the matter. And quite often judges have to decide the matter, okay. So they will find them guilty, okay, and then they will have to punish them, okay. Now once the war is over, okay, the same people were tried in a different court now, okay. For what? For denying liberties to the people, okay. So denying liberties, or unduly taking away others' liberties, okay, was already a crime under a previous penal law, okay, German penal code, okay, as it existed from the 19th century. So yeah, now they were tried after the war was over in new courts for denying liberties to these peoples about whom, okay, they had informed to the courts during the Nazi time, okay. Now, how would this matter be decided, okay? So Radbruch's position was essentially, this, as I told you, okay. So he argued that post-war German courts, okay, when this matter were being tried there, okay, they were right to convict the informers in disregard of Nazi law. The fact that, okay, they informed about such critical views, okay, within the laws, okay, in accordance with the laws as were there during the Nazi time, were not to be taken into consideration, okay. The fact that your act has led to denying liberties or life to others, that is reason enough to convict you. So this is what Radbruch's position has been. So why does he say so? He is essentially saying that these Nazi laws, okay, were so unjust that they were not to be treated as law, okay. So people who acted based on those Nazi laws did something wrong. Not just the people who informed, but also those judges during the Nazi times, okay, who convicted these people, okay, who were found to have had critical views, okay. So this is Radbruch's position, okay. So you see that in 1946, he had published the essay called Statutory Lawlessness, okay, or suprastatutory law. So this is where he had, revised his previous position, okay. So what is the formulation of his new theory? It's quoted here, okay, as you can see. The conflict between justice and legal certainty may well be solved in this way, okay. How? The positive law, secured by legislation and power, takes precedence even when its content is unjust and fails to benefit the people. So quite often we will say that, okay, this law which has been laid down is unjust, okay, but then merely because I think it is unjust does not make it less of a law. That's the general position, okay, because there will be always someone who would find the law to be unjust, okay. And then he said that secured by legislation and power takes precedence even when its content is unjust and fails to benefit the people, unless the conflict between statute and justice reaches such an intolerable degree that the statute as flawed law must yield to justice, okay. So he's setting a threshold, okay, and that should not be, the injustice should not cross that, okay. And if it crosses that tolerable limit, it ceases to be law, okay. After that, okay, if the law is applied on people, okay, whether the law is valid or not, that's the question that arises. If you were to ask the same question to H.L. Hart, he would say that, well, it is a valid law if it is in accordance with the rule of recognition. It is not a valid law if it is not in accordance with the rule of recognition. But Radbruch will say something else. Well, a law which is so intolerably unjust, okay, is not a valid law, okay. So it could be effective, okay, in the sense that a regime, okay, which imposes such law, okay, they might have the might, they might have the wherewithal, they might have the resources, means to apply the law forcefully upon people. But the thing is that then people will say that, well, the law is effective in the sense that it can enforce compliance, but then it is not valid, okay. And that's the position of Gustav Radbruch, who says that if the law crosses this threshold of intolerability, unjustness, then it is not a law. Then judges ought not to apply the law, nor will I have a not just moral obligation, okay, but also because it is not legally valid, so it will not create any legal obligation on me either. So you understand the distinction here between the position as held by H.L. Hart and the one that is held by Radbruch. Is it clear? Guys, am I audible? Is the distinction so tell me, my question is simply this, okay. So what is the difference between H.L. Hart and Gustav Radbruch on the question of legal validity?
So according to H.L. Hart, anything that is acceptable or has been or is applied by the officials is valid law.
No, the question of acceptability of who? Acceptability by whom?
By the officials, by the judges.
Okay.
Is valid law, and does not matter how unjust it is. If it is acceptable, it should be applied. On the other hand,
it's not acceptability of one individual judge, okay, because that's not going to be the case. So it is possible that
all the officials.
Of official generally. So that's the empirical reality from outside, okay. That's what. So you have to be specific about that. Yes, go ahead.
While the Radbruch formula says that you can judges can go against a statute only and only when the statute seems unbearably unjust or has a deliberate disregard for human equality before law.
Okay.
So he gives that even if it's acceptable, but if if there is a situation where it is invariably unjust, it is not a valid law, or judges should give their decision against the statute.
Okay, so that's essentially the difference. Okay, for H.L. Hart, he would say that law can be unbearably unjust, but if it is in accordance with the rule of recognition, it is law nonetheless. Okay, then whether we have an obligation or not is a different question. We might have an overriding moral, obligation to not obey the law. Okay, but legally you are obliged. But our philosopher here, Radbruch, is saying that if it crosses that threshold, you do not even have a legal obligation, okay, because it ceases to be law, okay. That's the difference in position between H.L. Hart and Gustav Radbruch. But I believe it's Pranav Gandhi's project topic as well, so he's already prepared for this. So someone else who would like to help me out? What is the relationship between legal validity and effectiveness according to H.L. Hart?
Sir, H.L. Hart talks about legal validity to be in a rule of recognition.
Okay.
And he says that it is independent of its efficiency.
Okay.
Effectiveness.
Okay. But then is there no connection between efficacy and legal validity at all?
Sir, there is, but I'm sorry, sir. Sir, but he has mentioned something about that, but I'm not able to read.
So, what is effectiveness of law?
Sir, effectiveness of law is whether it is the rule or the validity really works.
No, not a question of validity. Anyone else who would like to tell me? Yes, Swarna, what is effectiveness of law? I remember having explained it. So yes.
Sir, if most of the population follows the law, then it is said to be an effective law.
Okay.
But say you gave an example of a Russian law, I cannot recall the name, which is recognized under the rule of recognition, but is not at all followed there anymore.
No,
It is
it's not
effective.
specific. It's not specific. You have rightly recollected, but it's not specific law. So the existing laws which are applicable in Russia is definitely not the laws that existed during the times of Tsar.
Yes, Azar.
Why? And they are not valid now. Okay, they are not legally valid now. Why? Because the overall legal system became ineffective. Okay. Okay, so if the legal system in itself becomes completely ineffective, then the question of validity, does not even arise. Okay, that's what he says. Okay, but if a legal system generally is effective, but one or two laws are less effective than the others, or you can say not that effective as others, that does not make that law invalid. That's essentially what he says. Okay, so both of you are correct on that. Okay, just that it's not about one law. Okay, so it is possible that a legal system is generally effective, but then government comes up with a stupid law which is not followed by the people. Okay, so for example, you see this entire farmers protest going on right now. Okay, becomes law. Okay, it may be ineffective because people do not want it. Okay, the farmers don't want this law. Okay, but then if it is enacted into law, will it not be law? H.L. Hart would say that it will be law because it is in accordance with the rule of recognition. Okay, so even if it is not effective, okay, there could be many other such laws. Okay, because every other day we get away with breaking laws here and there. We jump the red lights. Okay, many people do not pay their taxes; they run away. Okay. With money. Okay, so these things happen, but that does not mean those laws do not exist and that they are not valid. They are nonetheless valid. Okay, but if the overall legal system fails, okay, if it is completely ineffective, okay, then obviously the laws will not be valid. Okay, then it does not make sense to talk about validity of law at all. So that's H.L. Hart's position. Now, Gustav Radbruch's position on this is different. In what sense? It is that for Radbruch says that, well, law will be valid even if it's unjust, okay? But if it crosses the threshold of unjustness, okay? If it crosses the limits of tolerability, okay? Then after it crosses that limit, it is invalid. Okay, it could be effective though. It could be effective in the sense that a repressive regime might have the force, might have the wherewithal, might have the resources to enforce obedience. Okay, so the law is effective. Okay, it can effectively get compliance on the part of people. Okay, but then it's not valid nonetheless. Okay, that's what Radbruch's position essentially is. Okay, so yeah, I hope the distinction is clear to you. But H.L. Hart will not say that. Okay, H.L. Hart would say that the question of effectiveness does not arise in the first place. Okay, for him, it's only when the legal system is not effective at all. Okay, so if it is not effective now and then, even in that situation, it could nonetheless be valid. Okay, and secondly, in H.L. Hart's discussion, the moral question does not even arise. Okay, the moral quality of it will not determine its validity at all. Okay, unless that is the requirement of rule of recognition, then it's a separate question. So, for example, I told you other day that Constitution itself might set certain moral requirement that the laws have to be in accordance with that. Otherwise, courts are given the power of judicially reviewing the law and then saying that, okay, it's not a law. Okay, so it's not an invalid law if it is against, for example, right to life or liberty guaranteed to you under Article 21. So that's a moral, what should I say, precept right there in your Constitution. But that's there because it is accepted by the rule of recognition. Okay, that's the position as has been held by H.L. Hart, and that's the distinction between those who say that law and morality do not have necessary connection and those who say that law and morality in fact has necessary connection. So anyway, this is what he says, okay, that if it reaches, okay, such an intolerable degree, that the statute as flawed law must yield to justice. So if it crosses that limit, then we don't follow the law. So yeah, so that's the position as was held by Gustav Radbruch. Okay, so this I hope is clear to you. Okay, so it says that in such case it nullifies all laws, okay, of injustice and is beyond reasonable doubt. Okay, so that's his position. Okay, so he proposed a moral test, okay, as I read it out to you, that applies to all positive laws. Okay, and what is that? And it is that it not just applies to us, the individuals, but also to judges. So a judge who comes across, okay, such a conflict between a statute and what he perceives to be just, okay, and he has to decide against applying the statute. Okay, that is the position. Now, during the war period, we did not have any positive law that would lay down such standards for us. Okay, but as of now, there are such standards at the international level. Okay, so Rome Statute of International Criminal Court, okay, it establishes certain courts. Okay, under Article 1 it establishes a court. Okay, and then it also in Part 2 with respect to jurisdiction, you will see it lays down different kinds of crimes. Okay, so if such laws are created that, for example, validates genocide, okay, crimes against humanity, war crimes, okay, aggression, etc., etc., in those situations, you now have a framework, okay, at the international level at least, to at least have the reason to decide against the validity of the law. Okay, so it's much easier for the judges as of now. It wasn't so back then. But one problem nonetheless remains. Okay, now if you were a judge, okay, if you say that, well, it's not a valid law, then there is a threat to your own life, because Führer is there. He'll say that, well, you are not working in accordance with, my dicta, my orders. Okay, what will you do? Because it's your life versus, justice to someone else. Okay, that's the moral predicament that we still need to address. Okay, so we'll see in the course of time. Okay, but for now, let's look at H.L. Hart's criticism. Okay, so Hart disagreed with what Radbruch had to say. Essentially, Radbruch's position that an unjust law, an extremely unjust law, is not a law. It's not a valid law. Okay, so he had this elaborate debate with Fuller that we are going to talk about. Okay, but in this article by the name "Positivism and Separation of Law and Morality," okay, he defends his own version of legal positivism. Essentially, the idea that we discussed already. Okay, and there he raises two criticisms of this Radbruch formula or the Radbruch doctrine. Okay, the first criticism was that he said that Radbruch had confused the distinction between legal duty and moral duty. Okay, well, we saw what Radbruch is saying. So he is saying that H.L. Hart is saying that, well, even when the law is unjust, it creates a legal duty in your favor. Okay, it creates a legal duty. Okay, but you might have a bigger overriding moral obligation to not follow the law, to disobey the law. Okay, that's his position. Okay, that's what he says. Okay, so yeah, but you nonetheless have a legal duty to obey inhuman law. Now, what is the implication of this position? Okay, the implication of this position is simply this, that those officials, those people who enforce the law, okay, we cannot really blame them for what they have done, because they have done what they were legally required to do. Okay, so that's his position. Okay, they had a legal duty. Okay, but yeah, they might have a moral duty to not do it, but the fact that they have done what was legally required cannot be denied. We cannot say that what they have done was not legally valid. We cannot say so. This is H.L. Hart's position. But what would Radbruch say? Radbruch would say that, well, those laws were so intolerably unjust that they did not even create a legal duty. So this is what has been criticized by H.L.A. Hart. When he said that Radbruch confused the distinction between legal duty and moral duty. So according to Hart, one may be under a legal duty to obey an inhuman law, but have an overriding moral duty to disobey it. Okay, so that's his position. But the thing is that if I have a moral duty, okay, I might disagree about what I'm morally required to do. So then what will I be punished for? Because I cannot be punished legally for a moral infraction. Okay, because you might find someone who has done something which is morally wrong. Okay, but you cannot punish that person. Okay, because there is no legal requirement for you to act morally in such situation. So what do we do with these judges and officials, for example, who enforce such morally reprehensible laws? So H.L.A. Hart had a different solution for that. Okay, so essentially that was the first criticism that he raised as against Radbruch. His second criticism was that the Radbruch doctrine, he said, by denying legal status to inhuman laws does more harm than good. Okay, so what does he mean by that? Okay, so he's saying that when Radbruch says that unjust law is not even law, when he holds such position, he is doing more harm than good. Okay, what is the harm there? Okay, it creates confusion for us. It creates lack of clarity for us, and that's the harm that he is referring to here. Okay, so by denying that, denying a law the quality of being law because it does not have certain moral quality, we are just creating confusion, and that's the reason that positivism had come into come into existence in the first place. Okay, so when Radbruch comes up with his doctrine, he's saying that you are creating more confusions for us, so you are doing more harm than you are doing good. Okay, so he criticized him for extraordinary naivety and of having only half digested spiritual message of liberalism. So why is he referring to liberalism here? The idea of liberalism is essentially this, that we have to be tolerant of other ways. Okay, we have to be tolerant of other ways. The question is that to what extent should we tolerate other ways? What if other ways are violative of liberalism itself? In such case, should we be tolerant of such problematic views which are intolerant of liberalism? Hart would say that yes, liberalism says that we have to be tolerant of other ways. Okay, but Radbruch would disagree. Okay, if it is in negation of the very idea of liberalism, then obviously we cannot be tolerant in such situation. Okay, so the question is essentially about toleration of intoleration. Okay, H.L.A. Hart says that liberalism requires that you are tolerant of intolerant views, whereas Radbruch would say that no, we cannot be tolerant of intolerant views, because if we allow that, then liberalism will not exist in the first place. Okay, so to generalize the idea, I have a question here. So while applying the concept of unbearably unjust, we are using moral thought. So isn't Radbruch using natural law? Yes, obviously. He is nowhere saying that he is not using natural law. But the kind of natural law that he is referring to is not referring to every other question, okay, on which we might have a natural law answer. Okay, he's talking about something on which we will all agree. Okay, the right thinking people, the reasonable people will agree. So I gave you many such examples. Okay, what if a law is enacted by your parliament that says that everyone whose hair is longer than certain length should be killed off? Okay, everyone who wears specs should be killed off. Okay, do you think such laws will be problematic, or do you think such laws are okay? Anyone who thinks that such laws are okay? This seems to be problematic. Okay, very clear to us. So yeah, if such a law is enacted, okay, into law, then we will all know that, well, this is intolerably unjust. Now let me rephrase this. Okay, if certain laws are created that denies you citizenship based on your religious background, what would you say to that? If If it, for example, takes away your landed property because you belong to a particular group, then what would you say to that? If it denies you education, if it denies you your healthcare rights, etc., because you belong to a particular group, okay, what would you say to that? Will such laws be just or unjust? We will have answers to this, okay, but in some cases it's crystal clear, in others it is not, okay. So we know where the line is crossed, okay. It is very much possible for us, and there will be not much disagreement about it. But the problem is that if you were living, for example, in Nazi Germany, and if you belong to the Nazi party, and if you were a sympathizer or you subscribe to those ideas, you would think that in annihilating Jews, you were doing the right thing. You were doing the right thing. That's where the problem is, okay? Quite often the people who are wrong, they genuinely believe that they are doing the right thing, okay? That's where the problem is, okay? That is something we have to address separately. But at this stage, let us accept that it is possible for us to know what is outrageously, problematic. And if it is still doubtful, then obviously refer to the statute that I just referred to, okay? Statute of Rome Statute of International Criminal Court. You refer to that and you will know the laws which could be extremely problematic, okay? So yes, that was his criticism, though, okay, of what Gustav Radbruch had to say. So in tomorrow's class, we'll discuss about certain problems, certain answers that you can provide to Hart's criticism of Radbruch, and then we will start our discussion on Fuller. So that's it for today.